So that gives you an idea about what we've been up to since 2010. A lot of our work has been around the judicial retention elections, especially the Iowa Supreme Court justices that have been attacked. In 2012, we were successful in protecting Justice Wiggins, who's been a great justice for this state for many years. And since, there's been a lot of attacks on the system itself in how judges are put on the bench in Iowa. And I'm going to talk a lot about that history and how that system works now. So that video is a lot about judicial retention. I'm going to talk a lot about the judicial selection system, how those judges get to the bench in the first place. Because political extremists continue to attack our courts and will continue to. This will be a fight for many years to come. And when extremists and lawmakers in our political branches of government try to control the judicial branch, what it does is it weakens the stability of our democracy, and it weakens the checks and balances. The courts are meant to be independent. They are not meant to be controlled by the political branches of government. And that's what you're seeing attempts at the legislature now. This is a quote. It says, "I hope the day will never come when persons will be put upon the bench to carry out political or party principles." That is a quote from William Penn Clark, who was a framer of the Iowa Constitution. He wrote that in 1857, and it's a hope we're still working to protect today. But it's important to understand the environment in which he delivered that quote. Before our state was even born, the High Court of the Iowa Territory, not yet a state, the Iowa Territory, established an atmosphere of equality for residents of this state. In 1839, that case, In re Ralph. 7 years before our statehood, the Iowa Supreme Court blocked a Missouri slave owner from seizing a former slave named Ralph who had come to find work in Iowa. They ruled that equal treatment under the law extends to men of all colors and conditions. In 1868, our courts integrated schools 86 years before the U.S. Supreme Court. In 1869, the first woman in the country to become a lawyer was an Iowan. In 1873, an Iowa steamboat passenger was denied access to a dining car because she was black. Our courts called it gross injustice and positive wickedness. And this was years before Rosa Parks had even been born. And as every Iowan knows, and as we talked about in the video, our courts ruled against marriage discrimination in 2009, 6 years before the U.S. Supreme Court. So it's within this proud judicial history in Iowa that we have also our Iowa judicial selection system, which is a big source of pride for this state. At the state and federal level, there are 3 general ways in which judges are selected, and so I'm going to talk about those 3 ways. I'm listing them in order of very worst to best. In states that elect judges, like politicians, much of the South has judicial elections, but there are judicial elections in all parts of the country. In those states, political parties or interest groups choose and fund candidates. Sometimes it's Democrats versus Republicans, but more often it's unions and trial lawyers, environmental groups, civil rights groups on one side, and corporations, manufacturers, and certain religious organizations on the other side. Just like in political races, candidates make promises about how they will rule before ever seeing the facts of a case. It is no way to run a court system. It is not a fair and impartial justice system, and it puts justice up for sale to the highest bidder. That is the worst way to choose judges. The federal system, which you're all, I'm sure, very aware of, the last 2 U.S. Supreme Court appointments have been the most politically charged in our country's history. That system is absolutely broken, and it's getting worse. When an executive, like a president or a governor, is given the power to unilaterally choose nominees to the court, we end up with judges whose first qualifications is their ideology. It's led to the mess that we now have at the federal level. But Iowa does judicial selection better. Our judicial nominating system evaluates candidates and selects the most qualified, sending a list to the governor who makes the final choice. It's called merit selection because it puts fairness, impartiality, and qualifications ahead of politics. 22 states use some form of this system. Iowa's, I think, is the best. It produces well-qualified judges, and it keeps political motivations at bay. From our perspective, it's proven to work better than all known alternatives. The merit selection system in Iowa ensures accountability and transparency. While judges are nominated by a commission, they're chosen by the governor. And we, as voters, have the final say with retention elections at every level, district court and Supreme Court and Court of Appeals. So that's the way our system works. As I said, we've got Supreme Court, Court of Appeals, and district courts. There's one statewide commission that chooses judges and justices at the Court of Appeals and Supreme Court level. And then there are separate judicial nominating commissions for each one of the districts. There are some sub-districts inside the district courts. There's actually 14 district court commissions that all have their own commissions that select judges for their area. So the State Judicial Nominating Commission just finished vetting candidates for an open seat on the Iowa Supreme Court, so they serve as a timely example. The State Judicial Nominating Commission is made up of one judge who serves as the chair. Currently, that's Justice David Wiggins. The rest of the commission is made up of 8 commissioners that are chosen by the governor. We actually wrote 7 there. That's not correct. It's 8 on the slide. So 8 commissioners chosen by the governor and approved by the Senate. And then 8 attorneys that are elected by their peers. Commissioners serve on staggered 6-year terms, so that if there's a new governor, the change on the commission is gradual. And there's an equal number of men and women on the commission, and 2 commissioners from each congressional district. So there is gender and geographic balance on all of these commissions. There's often confusion about how the attorney commissioners are chosen. Many politicians believe that the Iowa State Bar Association just handpicks these attorney commissioners. But the Bar Association has no role whatsoever and no power whatsoever in the system. Any licensed attorney can run for and vote for seats on these commissions, and the judicial branch administers the elections. So you may hear in the newspaper or up on the Hill politicians saying, we don't want the Bar Association to control what goes on with the nominating commission, but that's just not how the system works. They have no power at all. Many politicians also believe that Democrats hold a majority of the seats on these commissions. There was probably a time, well, there certainly was a time when that was true, when there were Democratic governors. That is not the case right now. Democrats don't make up a majority of any one of the 14 district commissions or the statewide commission. In fact, if you tally up all the governor's appointees and all the elected appointees on the nominating commissions throughout the state, it's 62% Republican and just 30% Democrat, and the rest are no party. So anyone who tells you that Democrats have too much influence on the system is completely uninformed about how the system works and how it's made up. So when Justice Hecht announced his retirement a few months ago, Justice Darrell Hecht from the Iowa Supreme Court, the process began for filling his seat on the court. There is an application period where any licensed attorney can apply. 19 Iowans applied for it, including current judges, private attorneys, and government attorneys. The full commission interviews each applicant. It's open to the public. It's streamed live on YouTube. Some of you may have seen some of the interviews. There are some very good candidates that apply. There are some not so good ones that apply. The beauty of the system is that it keeps those bad candidates from really ever coming forward, those truly unqualified people. And it's clear in the interviews, because you can watch them on YouTube, who some of those people are. And then the governor, they put 3 names forward, and the governor can choose from just those 3 names. So the way the system is set up is that hopefully the governor can not make a bad choice because she is limited to a pool of people who are identified as completely qualified. So the names that came forward, they just came forward last week. There are 3 of them. Judge Kellyanne Lee Carr, who is the chief judge for the district that includes Waterloo. She's a great judge. Judge Christopher McDonald, who's currently on the Court of Appeals, and Judge Dustria Ralph, who serves in Corydon, which is in south central Iowa. All of them are qualified, and Governor Reynolds has about 25 days to make her choice. So that's how the system works, especially at that Supreme Court level, and we'll see very soon who will be the next Supreme Court justice. So over the years within this system, unions have gotten a pretty fair shake. Here's some examples. 27 years ago, in 1992, state employees from 3 Iowa unions negotiated and won pay increases in binding arbitration. The contract was set, yet Governor Branstad vetoed the pay increase and violated the terms of the contract. Union leaders took their case to court, claiming that this violation of contract was unlawful, and the Iowa Supreme Court sided unanimously with the unions and ordered the state to honor the pay increases. Fast forward to 2012, the Iowa legislature secured the funding to keep Iowa workforce development offices open all across the state. This will be familiar to a lot of you. Governor Branstad, who wanted to replace those jobs and responsibilities of the field workers at these offices with computer terminals at local libraries, vetoed this provision out of the budget and kept the funding. Union leaders thought this move was unconstitutional. The Supreme Court sided unanimously with you, Iowa's unions, and over the state's chief executive that had appointed most of them to the bench. This is a court that Branstad had appointed the majority of the 7 Supreme Court justices. So not a single justice from the 1992 court remained on the bench in 2012, yet 20 years later, the court came to the same conclusion about the lawfulness of the governor's veto. So that is the sort of consistency that our judicial system provides. A more recent example, and I think a really good example, comes from 2017, from a 2017 Supreme Court opinion. You may remember when Governor Branstad tried to remove the Workers' Compensation Commissioner, former Workers' Compensation Commissioner Christopher Godfrey, from office, despite the fact that his position was designed to be protected from the political whims of a governor. Branstad went so far as to admit in an interview on WHO radio that the Anti-Union Association of Business and Industry were the ones pushing him to get rid of Godfrey. And Commissioner Godfrey, to his credit, would not back down to Branstad, so Branstad cut his pay by $30,000. Now, interestingly, Godfrey was hired to be the chair of the federal workers' compensation panel, essentially being the highest judge in the land on this issue. So it was clear that he was one of the best and most qualified commissioners in the state, but for political reasons, Governor Branstad wanted to get rid of him. Godfrey sued the state for discrimination and political retaliation. Branstad and his lawyers pushed hard to have the case dismissed before it could go to the jury. And the Supreme Court sided with Godfrey, not Branstad, in a historic ruling. Again, this is a court made up primarily of Branstad appointees, and they sided with Godfrey on a very controversial case, and they sided the right way. So this case will go to a jury. I say this every year, it keeps getting pushed back. Hopefully this year, finally. So stay tuned, because it will be a great case for a jury. So regardless of makeup and regardless of ideology, regardless of parties involved in the case, Iowa judges tend to follow the law. That's not to say workers win every case. My members trial lawyers in Iowa. They go up against, take cases to the Supreme Court and district court all the time. They may not even win a majority, but they believe in the system, and they believe that the system is working well. It simply shows that anyone who takes their case before an Iowa judge can and should count on a fair result based on the facts and the law. So you don't always find this in other states or at the federal level where politicians or politics is a driving motivation in the selection of judges. Compare the Iowa rulings I just talked about with what we just saw at the federal level with the Janus ruling, where the U.S. Supreme Court outlawed union fair share fees. Now in this case, the U.S. Supreme Court overturned itself. It had just upheld fair share fees as recently as the late 70s. So how do we protect Iowa's superior system? As I mentioned earlier, this system has been around for well over 50 years, but it's more vulnerable today than ever before. Extreme political groups poured millions into campaigns to oust 3 exceptional justices in 2010, and over the decades since, they've called for the impeachment of judges. They've tried to move us to hyper-political judicial elections. And this year, politicians are going to try and rewrite our judicial selection system to shift more power to the political branches of government. So we don't know yet what the bill will look like. We understand that the bill will come out this week, and I can't tell you how extreme it will be because we haven't seen the language of it yet. But it will mean that Republican politicians will exert more influence over who gets to be a judge. And if that happens in Iowa, who do we think is going to benefit from the change? Is it going to be workers, or is it going to be powerful employers? And I think we know the answer to that. So we need leaders like you to stand up for Iowa's courts, and the Iowa Fed has been leaders on this for many years, so thank you. We need you to stand up and tell the truth about our system, because your rights absolutely hang in the balance. The courts review the constitutionality of laws that adversely affect your collective bargaining rights. The courts are the primary protector and enforcer of workers' legal rights. Employer wealth already weighs in favor of employers regarding workers' rights. So politicizing the selection of judges risks further tilting the system in favor of employers. So I want to thank you for your continued support on this issue. You guys have been here for this issue for years. I want to thank you for your commitment to protecting fair courts. We've held off lawmakers in every attempt they've made to inject politics into our courts, but this is going to be our biggest challenge yet. Again, unfortunately, I can't tell you what that bill will look like, but I can tell you that there will be a united front to stop it. And I hope you guys are a continued part of that. So thank you. I don't know if there's any questions about the current makeup of the court, or any questions about how the system works, but I'd be happy to answer them to the best I can, and I'll stick around for a little bit if folks have any questions. So, thank you.
Is there a question this week about the abortion bill? What it's called?
The Planned Parenthood decision?
Yeah.
What's the question? Is there a question about what about it?
Aren't they trying to, well, they're always trying to push back on legal abortions?
Yeah.
Is there anything going on soon?
Well, there was an Iowa Supreme Court decision that found a fundamental right to an abortion in the Iowa Constitution, and that has upset some lawmakers in the legislature. It's not, I wouldn't say it's a driving force behind what's going on with the merit selection system. It's kind of on the edges. It has, added some anger to some politicians who are already inclined to try to politicize the system, but we haven't seen it be the central, the central factor or the central talking point on their side so far. But we'll see. Legislatively, I don't know what's necessarily going on with that issue. I just know that there was an Iowa Supreme Court decision on it not too long ago. Yeah.
I would just like to say, as an employee of the judicial branch here in Iowa for 23 years, I've seen judges come and go. And a majority of the judges who have to go through school in Nevada come back.
So people can hear you.
A majority of the judges, all the judges have to go to school in Reno, Nevada for judicial instruction. And when they come back, they are always so proud of Iowa having the selection process that we have, and that many of the judges who come from all over the United States at that time are saying that Iowa has the best selection process for our judges. And so I hope that we can continue this process and stand with the judges, because you should ask the judges that are in your counties, and they'll be happy to share with you the information and their feelings about how they got there and so forth. And at this point in time, in Polk County itself, we were able to get a Latina for the first time selected as a judge for our juvenile judicial seat. So I'm very happy that this happened, because we need to diversitize our judges on the bench at this time, because I'll let you know, we're not going away. Our population is growing. All diversity cultures are growing, and they need to be serviced and see people like them on the bench who are making decisions. So I worked on the Supreme Court when they were trying to get rid of those judges. I worked with the committee, the trial lawyers, and the Iowa Bar Association, and I will continue to do so, because we need to make our judicial branch safer and stronger. And I would say that remind people to turn that ballot over when the time comes for retention.
Absolutely.
And supply them with the information that they need to continue to back and retain the judges that we have on the bench.
Thank you, Paula. Any other questions for Andrew? All right, Andrew, thank you for being here and talking about this important issue.